A very good morning to you. Welcome to this special sitting of the Senate. It is the session that has been organized to hear and determine the proposed removal from office by impeachment of Honorable Ferdinand Ndung'u Waititu Babayao, the governor of Kiambu County. Yesterday, the Senate did convene where there was a pre-hearing meeting for senators, and it was a closed session, and thereafter there were preliminaries where there was recital of the mandate of the Senate, rules of procedure and hearing program, and also introduction of members of the County Assembly of Kiambu representing the County Assembly and their council. And also there was the introduction of the governor and the council representing the governor. The charges were read yesterday, and there were opening statements on behalf of the County Assembly, which took 30 minutes, and opening statement on behalf of the governor, which also took 30 minutes. Thereafter, the senators proceeded to a lunch break, and at 2 p.m., the House convened again, where evidence by the County Assembly was adduced before the Senate, and this was evidence of witnesses, and there was also cross-examination and re-examination. Thereafter, there were questions and requests for clarification by senators before the House finally adjourned. This morning, the House will begin by hearing the evidence by the governor, and the governor will be called upon to call witnesses, if any, whereby there will be cross-examination and re-examination. Thereafter, there will be questions or requests for clarification by senators. After that, the senators will proceed to a lunch break at 1:30 and resume this particular sitting at 2:30, where there will be closing statements, one on behalf of the County Assembly, which is estimated to take 60 minutes, and the other on behalf of the governor, which is also estimated to take 60 minutes. Thereafter, there will be deliberations, this one by the senators, and it will be in a closed session. And this deliberation will last approximately 2 hours, and thereafter the session will be open again, and that particular session will involve voting. Thereafter, the House will adjourn, marking the end of the gazetted 2 special sittings. This broadcast is brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation. The broadcast is available on Senate TV as well as KBC Channel 1. You can also stream this particular broadcast on YouTube, courtesy of the Parliament of Kenya. Governor Ferdinand Waititu Babayao was impeached on 19th of December 2019 by the County Assembly of Kiambu. Thereafter, that resolution was forwarded to the Speaker of the Senate, prompting the Speaker to convene a series of special sittings, which one of them takes place today. And the governor has been accused of gross violation of the Constitution, the County Government Act, the Public Finance Management Act, and the Public Procurement and Disposal Act. Here, the County Assembly of Kiambu argues that there's lack of accountability in the management of county resources by incurring unsustainable debt and other pending obligations to the tune of 4 billion shillings. These pending obligations, they say, were never disclosed in the County Fiscal Strategy Paper 2019, thus violating Article 201E of the Constitution 2010 and Section 107, Subsection 2E of the Public Finance Management Act of 2012. If you're just joining us, business of the Senate on this 29th day of January 2020 is about to begin. Now I will hand you over for the live broadcast of this special sitting of the Senate, where this morning Governor Ferdinand Waititu will defend himself. Good morning.
Let us pray. Almighty God, we beseech you to behold with your abundant favor and blessings as your servants whom you have been pleased to call to leadership positions in this republic. We seek guidance to treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen.
Order number 1, communication from the chair. Order number 2, hearing and determination of the proposed removal from office by impeachment of the Honorable Ferdinand Ndongo Waititu Babayao, the Governor of Kiambu County.
Okay, Honorable Senators, let me welcome you back to this morning's session. And as you can, from our program, today we are starting with receiving evidence from the Governor. Therefore, Governor Waititu and your team, you are most welcome.
Thank you, Honorable Speaker, Honorable Senators. Now, before the Governor proceeds to tender his defense in this impeachment, yesterday, Honorable Speaker, you pronounced yourself on the request to admit the Governor's documents filed outside the prescribed time, and you deferred that application to the hearing of the defense case. And so before the commencement of the Governor's defense, we propose, Honorable Speaker, Honorable Senators, to revisit that application. And it is that application, Honorable Speaker, that I would wish to urge and invite your determination and ruling on. Mr. Speaker, this application relates to a request to admit the Governor's documents outside the prescribed time. Mr. Speaker, the foundation of this application is to be found in the following enabling provisions. We rely on Part 1, Rule 29 of the Rules of Procedure. We also rely on the Constitution of Kenya, Article 129, 2D. We also rely on the provisions of the Fair Administrative Actions Act, Section 43A. We also rely on the previous precedent set by this Senate. Mr. Speaker, when the governor was served with the invitation to appear on the 22nd of January 2020, he had 3 days to put together his evidence. In doing so, Mr. Speaker, he needed access to his office, which at the time was a challenge, owing to a subsisting injunction barring the governor from access to the county government offices. Honorable Speaker, to enable the governor substantively respond to the issues in the invitation to appear, he needed to consult with technical persons within the county government who would then provide him with the material necessary to respond substantively to the issues in the invitation to appear. There was a delay in receiving those documents within those 3 set days. In the circumstances, Mr. Speaker, it was difficult for the governor to put in his documents on the 25th by 5 p.m. Mr. Speaker, failure to comply with that timeline was neither deliberate, neither was it as a result of dilatory conduct on the part of the governor. Mr. Speaker, the governor only managed to present his evidence on the 27th of January 2020, 1 day outside the prescribed time. However, when he noticed that he was running late, he endeavored to put in a preliminary objection by the 25th of January, which was part of what he would be relying on, and as a demonstration of good faith, and that he had every intention to challenge and defend himself before the Senate. Mr. Speaker, when you're invited to make a determination on an application of this nature, Standing Order number 1 requires you to bear in mind the following. That the Assembly, Mr. Speaker, unlike the governor, had documents together long before the invitation to appear was served, and hence, in furtherance of the principle of equality of arms, the limited extension sought by the governor is fair and reasonable. Mr. Speaker, I wish to point out that when we realized that we were running late, we endeavored on Monday to drop a copy of those documents with the Assembly offices, so that by the time we are appearing on Tuesday, they had due notice of the documents and the evidence that we sought to rely on. That was on Monday, in the evening. And that was in good faith, so that by the time we are revisiting this application, the Assembly then had notice that inasmuch as the documents had not been received by the Senate, there was every intention to urge an application to have the documents allowed. Mr. Speaker, I also wish to mention that yesterday I'm informed that the Council of the Assembly was also furnished with a copy of those documents, inasmuch as they had not been admitted, again, so that they can have due notice of the content of those documents and so that they are not prejudiced during their case. Mr. Speaker, the nature of the evidence, because this is a critical consideration, touches on evidence of what transpired on the 19th of December, 2019. Attendance logs, which speaks to threshold, which speaks to numbers. This is evidence that this Senate is entitled to. Even without the governor moving the Senate, it is evidence that the Senate on its own motion can call for. So that it is in the interest of justice that all material, Mr. Speaker, that is irrelevant for the just determination of this impeachment be before the Senate for consideration. Mr. Speaker, Standing Order 1, as you exercise your discretion, requires you to bear in mind the provisions of the Constitution, provisions of the law, and even the forms and precedents of this Senate. Mr. Speaker, I just wish to remind the Senate that during the proposed impeachment of Governor Wambora and Governor Gachagua, there was indeed a request of this same nature, where documents were indeed admitted into evidence on the floor of the Senate on the date the impeachment proceedings commenced. So there is already a custom and a precedent. We're not saying that we did that because there's a custom and a precedent, no. But because this is a house of precedent and customs, it behoves it then to bear in mind that a precedent has been set before where an application of this nature has been considered and indeed granted. Mr. Speaker, we accordingly urge you very respectfully that you grant this application, allow admission into evidence the governor's response dated the 27th January 2020, and the list of authorities which we have attached thereto, and 2 witness statements of persons that were present on the 19th of December 2019 when the impeachment proceedings took place on the floor of the Assembly. I wish to mention again that yesterday we also had a chance to pass on to the office of the clerk just a copy of those documents, so that also administratively the Senate can have a chance to look at the nature of the evidence that we seek to adduce through those documents. However, Mr. Speaker, we invite your determination on this question and a ruling on it, and we urge you to find our application merited and that you grant it. Attached, or rather auxiliary to this, so that you can now make a determination on those 2 applications at this preliminary stage, is an application, Mr. Speaker, you remember arose yesterday during the hearing of the Assembly's case. And this relates to objection to documents, Mr. Speaker, which were filed by the Assembly in contravention of Rule 19 of the Rules of Procedure of the Senate. Mr. Speaker, Rule 19 speaks to introduction of new evidence that was not part of the allegation against the governor at the Assembly. Mr. Speaker, that rule, correctly understood, presupposes that the allegations and the evidence originally presented before the Assembly prior to the passing of the resolution to impeach, and which the governor was expected to defend himself against at the Assembly, must be the same evidence that the Assembly should rely on during the impeachment trial at the Senate. Mr. Speaker, introduction of new evidence at the impeachment trial stage at the Senate essentially means that the governor has been deprived a chance to defend himself against that evidence, since the first defense stage is at the Assembly level. And this, Mr. Speaker, is in keeping with Standing Order number 63 of Kiambu County Assembly Standing Orders, where it says, and I want to read verbatim, right to be heard. This is at the Assembly. That the person being removed, this is in this case the governor whose impeachment is sought, shall be availed with the report of the Select Committee. This is at the Assembly, together with any other evidence adduced and such note or papers presented to the committee at least 3 days before the debate on the motion. That is a standing order. So what it presupposes, Mr. Speaker, is that the evidence at inception when the motion was tabled must consistently be the same evidence that the governor is expected to defend himself against at the Assembly level, and when the matter is escalated to the Senate, must be the same evidence. So that, Mr. Speaker,
just a point of order.
Okay.
If Council can please refer to the correct, I think he's referring to a standing order that is no longer part of the standing orders. So we want to just give him the standing orders, and then he can make reference to the correct ones so that we have a correct record.
just get the right to be heard. Mr. Speaker, let my learned colleague, because the one I have, I got it from the internet, from their own website. In fact, this is a printout of that Standing Order 63 on right to be heard, but my learned colleague will clarify on the hard copy. So that, Mr. Speaker, the application that we are making is this, that when now the standing orders of this Senate says and provides under Rule 19 and prohibits introduction of new evidence, there is already a foundation because there has to be consistency. Because the case of the Assembly cannot keep mutating. It cannot mutate from evidence that was before the Assembly, then it goes to the Senate, it mutates into another case in which the governor is expected to respond to. So that's the rationale. The consistency must be maintained. So that yesterday, Mr. Speaker, and this was an admission by their own key witness number one, is that he made reference to documents that he considered were never served on the governor at the Assembly stage. And so those are the documents we are objecting to, Mr. Speaker, and urging that the Senate, in consideration of this impeachment motion, does not consider. And you'll find these documents being pages 1, 2, 3 to 33, 34, 35, 36, 37 to 42, 43 to 49, 64 to 74, 76 to 98, 100 to 120 of the Assembly bundle of documents. I wish, as I wrap up that submission, to also refer the Honourable Speaker to the rights to fair administrative action.
Order, Council. What's your point of order, Senator Murkomen?
Mr. Speaker, we need your guidance. To the best of my understanding, there was one application by the Council in regard to admission of evidence. But there is an argument I am hearing that is related to expunging of evidence of the County Assembly. Mr. Speaker, I have not seen that application. It hadn't been made before, or we were not put on notice insofar as that application is concerned. Why can't, is it not, Mr. Speaker, tidy for the Council to focus first on the application to admit evidence? You make your ruling, Mr. Speaker, and give directions to this House. Then now we can go to other issues. Otherwise, if it's jumbled up like that, Mr. Speaker, this House will be lost in making a decision.
Yeah, I think the leader of majority is right. Be careful, otherwise you'll end up mixing yourself up like yesterday.
I'm well guided, Mr. Speaker. We could reserve the second application on expunging documents filed in contravention of Rule 19 after you pronounce yourself on the request, though we had thought of just putting them together so that as you make a determination and as you exercise your discretion, because of course it's important to be fair to both sides, you also notice that there is an indiscretion on the part of the Assembly in as far as compliance with the rules is concerned. Because our case is that we haven't complied with a certain rule. It's important to point out that their case is also not entirely foolproof when it comes to strict compliance with the rules. But I'm guided, Mr. Speaker. You can make a determination after, of course, they have a chance to respond to our first application. And then we can take up or revisit the second application after your determination. Thank you very much, Mr. Speaker.
Council for the Assembly, do you have any comments before I make a ruling?
Thank you, Speaker. My name is Buthi Gadenji. I'm going to respond on behalf of the Assembly. First and foremost, the application before you is for leave to file documents out of time. The first important thing that this House should do is define those documents. The presumption from the application that is before you relates to two types of documents: evidence and pleadings. You will find that the council has not given a background of how they access this house. The only way they can approach this house is first compliance with the standing order number 6 of this house. And that obliges them, of the rules. This schedule of the rules. That obliges them to file an answer. And the answer is mandatory. And this answer must be filed within 3 days of the invitation under Rule 4A on a date specified in the invitation. Once they file the answer to the charges, then they have audience to go into the realm of documents. Now, the response itself under Rule 6A must be a response to particulars of the allegation. So that's the first document, and that is what places them here now. Before they talk about evidence to support that answer, or to talk about any evidence, they must first satisfy you that they have a base. It's our case, they haven't. So there are no pleadings, contrary to standing order number, should be rules. Rules of procedure in the 5th schedule. So all Waitito should do first, before he asks for any additional indulgence from this House, is to satisfy you that he has filed an answer or as required by Rule 6. The next thing is that the rules are very clear. Who should receive this document? It is the office of the registry. So besides providing for the content of the answer, there is a requirement that your registry, which is the office of the clerk of the Senate, that is Rule 6, should receive those documents. It is our case that our case has already been heard. In substance, we have brought witnesses and closed. It's our case that any admission of the answer to start with will require this House to start afresh if it is going to comply with equality of arm principles. The equality of arm principles, in brief, provides that you file your allegation against me, and I will file my answer in response to your allegation. Evidence rights. Evidence is based on the allegation and the particulars. So it is our case. They must be precise what they are looking for. Otherwise, you cannot exercise a discretion when there is a breach of a very fundamental document, which is the answer. Oral evidence has been given. Cross-examination, re-examination, in fact, examination, re-examination, they are all based on the answer. The equivalent in our civil proceeding is a plaint and defense. We cannot have evidence just brought into the darkness. And as I said, Mr. Speaker, the rules are mandatory. The timelines are mandatory. Before I go to the next point that I was going to raise, I do feel you are being asked to exercise a discretion. A discretion is where somebody has already confirmed he has transgressed the rules. First and foremost, you must consider the factors for denial of Senate on the exercise of discretion. One, the governor is a well-informed person of parliamentary procedures, the deadlines, the consequences, and the limit of Speaker's discretion. Waitito and his legal advisors had the relevant information contained in the allegation as early as that December, through to the date of receiving the invitation. They never tried to file even a skeleton answer or even a thread of a defense saying, for the time being, this is what we have. When we go before the Senate, we are going to make an application for substantive document. They have shown laxity, arrogance, and in actual fact, lack of good faith. As on the 28th of January, they had not even served an advance copy, a draft answer to the councils or to the House, giving an indication as what they expect to use in this chamber, and upon which they will ask for leave for any further discretion of this court. It is apparent the council never intended to argue any other matter except preliminary objection. And it is very good to be forthright and candid to this House. That is the style they wanted until the witness came and testified. The preliminary objection can only be based on information upon which they would have come to controvert the allegation. So they cannot come before you and say they didn't have anything. The other important observation is that the council was at this, Waitito had councils at Kiabu during the motion consideration. So they had materials upon which they could have filed a skeleton answer. Mr. Speaker, your discretion should not be trivialized. Somebody should not sit on his rights and come at the last moment. There is nothing. We have finished. The other thing, of course, as I said, there must be equality of arms. We exposed our case. If they come and file documents, file an answer, what are they going to say? And what are we going to say? So the dilemma you have now is reopening of the proceedings from the beginning. You have told us several times, and I have seen, you are time-bound. You have deadlines. We also may ask for leave to file counter documents, to file fresh statements. How long is this proceeding going to go? So in my view, the way forward is that this House should invite the Council for the Assembly to summarize its case through its submission and satisfy you that from the evidence adduced on the allegation has reached a threshold for removal of the governor in the absence of an answer. So my position, the position of the County Assembly is that the time for evidence is over. In your own discretion, you had given us time to consider this application. I also feel it is out of your magnanimity that we are arguing this particular application. You could have determined that in the absence of an answer, no more evidence, no more no examination at all should be carried out by the counsel for the governor. I would like my running friend to proceed further and just wind up the other area.
Mr. Speaker, just a few additions to what my learned senior has argued on. First, the request for additional, for evidence. It is very clear from the submissions that you have had that the governor is not asking to produce evidence about the allegations on his conduct. You've been told that the evidence is with regard to the logs and attendances at the county assembly. It is therefore clear that the governor has no intention of tabling any evidence with regard to the allegations. But what is curious is that the preliminary objection that was filed before you states that it is based on self-evidence, that the PO is self-evident on the available facts. So at the point that they filed the PO, they were satisfied that there was available facts that were already filed. Now, coming to the standing orders, we are told that the evidence that is supposed to come in is evidence to help you determine whether there was quorum at the county assembly. It's my humble submission that the Senate has no business interrogating that question in light of its mandate and its rules. The rules circumscribe what you are required to do. Rule 2 provides that the Senate shall in plenary investigate the matter and determine whether the particulars of the allegations against the governor have been substantiated. So the only thing you're supposed to be looking at is whether the allegations against the governor have been substantiated. Rule 19, which has been cited to you, in fact, precludes the county assembly from bringing evidence about the process in terms of who attended, who did not attend. It says, in presenting its evidence, the assembly shall not introduce any new evidence that was not part of the allegations against the governor. The question of quorum was not an issue at the county assembly, and there was no evidence about that. And therefore, the county assembly is precluded from bringing that particular evidence. This House is being asked to interrogate the resolution of the Speaker. In fact, the notice of motion expressly states that the Speaker of the county assembly is misrepresenting to the Senate. And I submit that when the Speaker received a notice from the county assembly of Kiambu, the presumption is that there was a quorum in that particular house. And it is not for this House to interrogate that question. And I pointed out yesterday that the standing order of Kiambu County has clear provisions for bringing out that question. Standing order number 98 provides, in case of confusion or error in counting occurring in the course of the roll call concerning the numbers or names recorded, which cannot otherwise be corrected, the Speaker shall direct the Assembly to proceed to another roll call. That is during the hearing. Second, if after a roll call has been made, it is discovered that the number has been inaccurately reported, or that an error had occurred in the names of the division, the fact shall be reported to the Assembly, and the Speaker shall determine that the necessary corrections be made. So the place where the governor ought to have raised the question of numbers is the House, is the county assembly. And the only way that the governor can now ask you to revisit that question if he had applied in the county assembly and been denied, and then he would be coming here to tell you that we made that application there, we were denied, and we think that you need to revisit. So it is my humble submission that no grounds have been submitted to warrant the request. The proceedings in questions were on the 19th of December. So it is not that the governor only learned about what is required to respond to 3 days from the time that he received the invitation letter. He was fully aware of what transpired in the county assembly from the 19th of December, and he had adequate time to prepare and put in those. So it is our humble submission that you should not allow the introduction of evidence. What we have here is an attempt to ambush the county assembly by bringing in evidence that we have no opportunity of interrogating. Lastly, Mr. Speaker, Council has submitted from the podium that the county assembly was given these documents. We have not received those documents. We have not received any documentation from the governor on the evidence that he is proposing to submit. And since we came yesterday, Council has not had the courtesy to give us copies of those documents as well. For those reasons, we would ask that you dismiss that application.
Thank you very much. Yes, Council.
Now, Mr. Speaker, a rejoinder on Senior Counsel Gadenji's submission that we did not file any answer or any pleading. I wish to point out, Mr. Speaker, that we filed a notice of preliminary objection on the process. That is a pleading. That is a pleading. That's a document contesting the Assembly's case. Now, you've been told, Mr. Speaker, that the nature of the evidence that we seek to introduce is just on logs. Far from it. My learned friend has not looked at the entirety of the evidence. There are material that speaks to the allegations on failure to, for instance, disburse funds to the county assembly, hence undermining their legislative authority. There are documents showing a schedule of members of the county economic budget forum. All these are documents, Mr. Speaker, that are part of the documents we propose to adduce, so that it is not entirely correct that our case is just on procedure. We are also attacking the merits. Yesterday, Mr. Speaker, and this is in response to the allegation that we are ambushing the assembly, we raised at the earliest opportunity before they conducted their case. And Mr. Speaker, in your wisdom, you reserved your determination of that question before or during the hearing of the defense case, so that the assembly had noticed that we'll be revisiting that question, so that the contention that they did not know what our case was is not entirely correct. I have stated, Mr. Speaker, and I am stating this as an officer of the court, that on Monday evening, when we were unable to get the document received by the clerk of the Senate, I dispatched my clerk to drop 3 sets of documents to the County Assembly of Kiambu. That was courtesy, that was good faith, Mr. Speaker. So that the allegation that we are ambushing them or these are sharp practice conduct is not entirely correct. Mr. Speaker, you have a discretion. It is a discretion you have. We have laid a basis and we have demonstrated to you, Mr. Speaker, that the evidence we have attached was not forthcoming to the governor within the 3 days. But what we did is that we made sure that within those 3 days, we raised a very critical objection on the issue of process, because that is the only issue we would have been able to respond to at that point in time. But as to the answer relating to the substance, it flows from evidence. So how would the governor have been able to respond substantively to the merits of the allegation without the evidence? That's a question. And that is why we are saying, Mr. Speaker, that given the basis that we laid earlier, we have demonstrated that the failure was not out of dilatory conduct on the part of the governor, and neither was it deliberate. There was every intention to contest these allegations. Mr. Speaker, I'll give Mr. Jenga just one minute to address the issue of the mandate of the Senate that Learned Senior Nani Mungai has addressed you on, the mandate of the Senate in this investigation. Thank you, Mr. Speaker.
Mr. Speaker, honorable members, I wish to address only two issues of the submissions made by only two issues raised by counsel. First, his submission was that the mandate and the power of the Senate is limited only to the investigation on the question of substantiation of the charges. Far from it. This Senate has had occasion to sit on over 8 impeachments proceedings. And in 2 of them, which I participated, and some of the members are still here, the Senate said clearly that part of its mandate is to investigate whether the process at the County Assembly was correctly carried out. At paragraph 75 of the report of the Mwangi Wairia Special Committee, which is within the records of the Senate settled this point. It said it is incumbent upon the Senate to determine if there was any violation at the County Assembly. That is paragraph 75 of the report of the Mwangi Wairia Special Committee. That was reiterated at the report of Professor Chepkwony, Governor Kericho, at paragraph 234, that the Special Committee has a duty to defend the Constitution in line with Articles 3.1 and 94.4 by confirming the propriety of the proceedings before it, that preceded the proceedings before the Senate. And that is the proceedings before the County Assembly. So part of your work is to confirm that the motion that was brought by the County Assembly before you was properly passed. That is part of your constitutional and statutory mandate. And that is a settled question by President of this Honorable House. Now, on the question of what is the remit of the Senate with regard to this nature of proceedings, Section 33 of the County Governments Act provides a very special jurisdiction to the Senate when hearing impeachment proceedings. It is not a judicial function. It is a quasi-judicial function that is described by statute as investigative. You are here to investigate. That is the word used 4 times at Section 33. And in an investigation, it is neither an adversarial or a court-centered process. The Senate has power to inquire as to the proceedings that preceded the matter coming to the Senate. And you have been told that some of these questions were not raised at the County Assembly. Witness number 1 confirmed that governor had sent 2 lawyers. He confirmed that these 2 lawyers were denied audience. They could not access the logs, they could not access any documents. They were told, go like ordinary Mwananchi and sit at the gallery and watch in peace. It is the same argument now being made that they should have intervened at the floor and confirmed about the numbers, confirmed about the evidence. It is a zero-sum argument that the governor had no opportunity to address the assembly through his advocates, yet he's been told today that was the forum. If you did not address the assembly, forever shut up. That is not the mandate of the Senate under Section 33. You're being asked to be very unfair to the governor by locking out any possible response. If you look at the documents which have been, which were submitted to this House on Monday but of course they could not be filed. They contain a response, or what our counsel is calling an answer to the charges. They contain particular documents, they contain arguments, they contain our list of authorities. If those are admitted, you will see beyond peradventure that what we have before you, and that is why there is a strenuous fight to lock these documents out. Senate should not see them, because if they see them, they'll realize that what you have before you are mere allegations. As I sit, I wish to reiterate precedents set by this House. I participated in the matter of proposed removal of Governor Gachagua. I was representing the county assembly, as my seniors are, and on the date we were before this House, standing at this very place, we were served with documents by the governor. And we considered, we did not even object. And the speaker then directed that those documents be admitted. He gave us 10 minutes to look at them and proceed with the motion. I suggest, and I propose, and I request that in all fairness, we made this notice of documents yesterday before the case started. We did not, it is not an overnight reflection or afterthought. We were clear in our minds, but we were directed by the speaker, and we obliged that hold your pace, make your application when your occasion comes. Today we are here. We have been told, no, you should have done that yesterday. Let us be fair to the governor, is all I ask.
Okay, honorable senators, before I use my discretion, I want to allow maybe 2 comments, if there are any. Okay, I think given the weighty matters that have been raised, I'm going to suspend the session for 30 minutes, and the Senate will remain in camera of the televisions and media so that they consult, and the council and the parties will be called after 30 minutes. It is so ordered.